Welcome to Case by Case. This is a podcast brought to you by Callum Chain and Luke Zadkovich from Zyla Floyd Zadkovich. Welcome, Callum.
Welcome, Luke.
How are you?
I'm good, thank you. We're back to just the two of us for the first time in season 2.
Oh yes. Back to how we used to do it.
Exactly.
I think we'll survive with this case, just the two of us.
I think we'll survive until we have the next guest lined up.
Yeah, I think we're going to have another guest next week. So looking forward to that. One of our US colleagues, Eva Maria Meyer.
And that's a good one. Next week's one. It's a point of law that I think is absolutely fascinating between the US and England. But we'll park that for next week's excitement.
Yeah, well, we've got a good one today. This has got some twists and turns. I've got quite a bit to say on this case. The decision we're talking about is a decision of the English High Court, the Commercial Court. The judgment was given by Sir Nigel Tier, sitting as a judge of the High Court. The claimant and owners in the underlying arbitration were Space Shipping Ltd, and the defendant on this appeal and charterers in the arbitration were ST Shipping and Transport. So as the name suggests, this is an appeal coming from an arbitration. It's a recent decision. The decision was handed down on the 13th of August 2021. So pretty much hot off the press, and let's get into the facts in a moment. But this is one of those classic arbitrations, and I think a really interesting one, Callum, in that there was a series of interim final awards that were given because the arbitration was commenced at a time when damages continued to accrue.
Yeah, and you can totally see why, when we get into the facts, why the arbitration was started when it was, and why the arbitrator dealt with it in the way that they did, by giving these interim awards, just almost chipping away at the amount of damages that were owed on each occasion. Yeah,
exactly. And one of the things that struck me, and that I know I always think about when I think about these cases, is if I was handling it, what would I do, or why would I be bringing the claim that I am, or defending it? What would be my strategy involved in this case? I think for this case, as it is for most, if not all, the cases that we talk about, the context is very important. And there is context here, which we'll get into, I'm sure. But there's context about what was happening up and down the chain in other arbitrations. And I dare say that may well have been affecting or impacting on some of the positions that were being taken in this particular arbitration, which is now before the court on a point of an appeal on a point of law.
Yeah, and maybe that's a good point to segue into the facts, which were a relatively routine charter party chain. We've got head owners at the top. They bareboat chartered the vessel to Space Shipping, who were the owners for the arbitration, as Luke said, who then time chartered to ST Shipping on a short-term charter party, which was for a number of months. I think it was 8 months, an 8-month charter from memory.
Yeah.
And very shortly after delivery into that charter party, the vessel was detained in Venezuela, and it was detained from September 2014, ultimately until October 2017. So a pretty enormous detention. And following the release of the vessel, it was then towed to Trinidad, redelivered to the head owners, and ultimately scrapped. There was a claim between Space Shipping and ST Shipping, in which it was found that ST were responsible for the detention, and therefore there was a damages claim brought against them by Space Shipping for hire up to the expiry of the charter party period, and thereafter hire at the market rate until redelivery. And essentially the question before the court here was whether or not ST Shipping were entitled to reduce their exposure to Space Shipping in an amount equal to the dry docking that Space Shipping did not perform, that they ought to have performed or would have performed in that period had they had the vessel doing its normal trade rather than being detained, which then throws up a number of other issues. But essentially that's the question that the court had to answer, a relatively constrained question on on the assessment of damages.
Yeah, and it was all about whether the deduction that was made in favour of charterers for the avoided dry dock expenditure should be a credit in charterers' favour or not. And I think it's interesting that the overall amount that was awarded in favour of owners against the charterers across these series of these awards was $24.4 million. And the dry docking costs that were avoided, I think, came to $1.4 million. So in the grand scheme of things, it wasn't a large amount by comparison to the overall award, but $1.4 million is $1.4 million. And there were twists and turns in the series of interim awards. There were multiple appeals over this issue. And then eventually the final award, if I can call it that, came for appeal on this point. And that's what the subject of this decision is. But there were two occasions prior to this. I think it was the interim award 1 and the interim award 4, that this issue of the dry docking expenditure had been dealt with against owners and been decided in charterers' favour. At least the first one was an indication of where that was going, and I think the fourth award was a definitive decision on that in charterers' favour. But right throughout, the arbitrator, and I couldn't see in the decision who was the arbitrator, and I wasn't sure about that, whether it's common not to name the arbitrator in these decisions, but any of them.
Yeah, it seems like it's almost 50-50. Sometimes they get named. I wonder if they were named in one of the previous cases.
Yeah, I wondered that too. In any event, we don't know who the arbitrator was, but was described as the most experienced maritime arbitrator. So no doubt one of the usual suspects. And the arbitrator was convinced throughout that there should be credit given to the charterers for the dry docking expenditure. And the point that I really wanted to make here, and it goes to the context issue, is it really seems that the owners kept beating, perhaps not a dead horse, but a horse on its last legs, because the arbitrator seemed adamant of what should happen on this point. It's almost strays into questions of fact and not just purely questions of law. It had been decided previously by the arbitrator and then appealed, with the court giving some indications what they thought on this point, and yet came back up again for an appeal. And I just wondered whether this was one of those scenarios where in an arbitration up the line, and ultimately the head owners are pursuing the hull underwriters and insurers for the constructive total loss claim. I just wondered whether this was a case of being seen to do everything you can to mitigate your position in this arbitration, and that's why they were really pushing this. Or maybe it's just they wanted the 1.4 million.
Yeah, no, I think you're right. There's every chance, and as is often the way when you have an arbitration between two private parties, then you don't often get the context that's going on around it, and that then flows through to the court case between the two parties. There was a procedural point that I thought was worth flagging here, which is that, as you say, that this has been appealed a number of times, and different partial final awards from the arbitrator had been appealed to the court a number of times without the need for permission. And normally that's a pretty big bar to getting your arbitration award that you dislike before the court. It's actually pretty rare that the court will accept permission to appeal. The test is high, and it requires either either something which is obviously wrong from the tribunal, or point of public importance, which is open to where the award is open to serious doubt. So you really need either something which is very clearly wrong on law, or alternatively something where the court can say, okay, what you're asking us to do here is interpret a routinely used provision, and therefore there's benefit to the law at large in us hearing this topic. But even then, the arbitrator's decision has to be open to serious doubt. So that high threshold would normally exclude a party from being able just to constantly run these points. What was important in this context is that there was a clause in the charter party by which either party was entitled to appeal to the High Court any question of law arising out of an award. And that means that you bypass the normal permission to appeal stage. And under Section 69(2)(a) of the Arbitration Act, the parties can appeal with the agreement of all the other parties directly to the High Court. And I think that's why we kind of saw such an industry of the lawyers involved, I suppose, in dealing with these issues in arbitration, and then with real regularity sending them up to the commercial court.
And do you think this is an example of where having that threshold to get an appeal before a court from an arbitration award is a good thing? Or do you think it's positive to have these types of rights of appeal written into contracts so that you have them as of an agreed right without the need for permission and getting over that initial threshold? One view is, well, the series of appeals to the court, particularly on points that seem to have been almost overlapping, is just a duplication of costs and just adds more burdens and weight to the whole process. The flip side, you could say as well, we're getting to talk about them. There is a body of jurisprudence building up over some of these issues that you wouldn't get ordinarily or as easily with that threshold in place. I tend to think if you're asking the paying parties of all this, they say, well, I'm not so sure about this provision.
I think that's probably where they would land on it. It seems like it's almost like the open door is there, so why not challenge it? And I think that, frankly speaking, for the parties here, the fact that they were entitled to and did appeal a number of these partial final awards was probably an expensive clause for them to include. It's maybe also worth flagging from a drafting point that you can do the opposite with a Section 69 appeal, and you can actually say there's no entitlement to a Section 69 appeal. Under English law, there are two different grounds to challenge an award on jurisdiction or on some kind of serious procedural irregularity. But then there's this third route, which is the appeal on a point of law, and the appeal on the point of law is one that you can actually contract out of. So you kind of have a menu of options as a contracting party, whether to say we don't want any appeal of law whatsoever, or alternatively to say any question of law from an arbitration award is appealable. Or alternatively, you take the kind of middle ground, which is the position in the LMAA terms, which then brings you to the permission to appeal stage.
Yeah, exactly. Because it's not universal, as we've talked about before in prior episodes. It's not universal that parties have rights to appeal arbitration awards. In the US, for example, you can challenge an award, but that's a different animal to appealing on a point of law and having that as a right, albeit with thresholds, as you have in England. So you could, in theory, if you wanted to devise a arbitration agreement where it was seated in London, subject to London arbitration law, the Arbitration Act of 1996, and have it subject to certain institutional rules, for example, you could do all that and then contract out of the appeal to make it more like the US approach in that respect, and just leave it to certain procedural irregularities or other types of challenges.
Yeah. So as parties do under the LCIA terms,
quite
round that off. That's the
exactly. So yeah, there's some interesting points on all that on drafting arbitration agreements. It's often not considered, in my experience, as much as it might be. And this is a case where you could say to a client, well, look, this is an example of what can happen with these types of clauses. Would you like the ability to do this, or is this a cautionary tale of what not to do? Okay, should we get into some of the debate about these dry docking costs?
Yes, I think we should. And for me, my interest in this case centers on one specific argument. There were a few that were run, but the one that I like the most is the one that goes to the new Flamenco case. I think that was their best argument, but I also like to see the new Flamenco in action because that's only a few years old. It was I remember tracking that case as it went through from the High Court to the Court of Appeal to the Supreme Court, because I was working on a file that was looking at damages and mitigation. And this case was just totally on all fours with the arguments that we were trying to run. And the Court of Appeal went one way that really helped us, and the Supreme Court then reversed the Court of Appeal's decision. So it was pretty disappointing.
Exactly. And this was all, in this case, this was all about the question. It was the second question actually posed by Sir Nigel Tier, that ought the arbitrator to have held that there was no sufficient causal nexus between the breach and the saving. There was a question prior to that, which the judge thought should be dealt with prior to the new Flamenco, but I'm more than happy to get into this one first, given your interest, Callum. I think it might just be useful for our listeners if we identify the argument here and then get into the new Flamenco. And what counsel for the owners was arguing here was that if there was a saving, this is a saving about the dry docking costs, that saving was not actually caused by the detention of the vessel, but by the way that the vessel was treated by the head owners and the owners. And I think that this is really the critical point to understand is, yes, there may have been a saving on the dry docking, but what was the underlying cause of that? Was it because that the vessel was detained, and as the arbitrator said, it was virtually impossible for the dry docking to go ahead because the vessel was detained? Or did the kind of causal origin of this saving arise because the head owners and the owners declared a CTL? And the owners submitted that was a question, that causation question was really a question of law, or alternatively a mixed question of fact and law. And then the court got into the new Flamenco. So I think perhaps if you want to take it on the new Flamenco and give a summary of that case, that might be useful.
Yeah, and that's exactly the background. So the new Flamenco then steps in, and the new Flamenco was a case where there was a early redelivery, a couple of years early, and across that period the market had dropped reasonably significantly. So the owners of the vessel, who are the innocent party, they'd had the vessel redelivered early, they claimed for their losses across the remainder of the charge party period on the basis of the difference between the market rate that they would have been paid and the higher rate they would have been paid and the lower market rate that they were in fact able to get for the vessel. I've kind of given away the punchline there, in that they in fact did not put the vessel into the market. Instead of putting the vessel into the available market, they sold it. And they sold the vessel for 23 odd million. And 2 years later, at the end of the charge party period, the vessel would have been worth 7 million. So the owners then brought their claim, and they said, our claim is based on the higher rate that we would have got from you, the lower market rate that we would have got if we traded the vessel. And they were relying on the old authorities like the Elena D'Amico that basically say that your measure of loss in the charge party context is based on the available market rate. And the charterer said, no, what you've done is sold the vessel, and because you've sold the vessel when we redelivered to you, you managed to, in fact, make a windfall of around 16 million because the value of the vessel dropped so dramatically over the 2 years that we otherwise would have had control of the vessel. And they said you would have had no opportunity to sell the vessel were it not for our early redelivery, and therefore you need to factor into your claim the credit that we should be getting for giving the vessel back to you 2 years early. And this kind of went through the courts and went through arbitration, went through the courts. The Court of Appeal said, yes, you selling the vessel was an effective mitigation strategy, and you have to give credit for the mitigation that you in fact do. And the Supreme Court then reversed that, much to my disappointment at the time, and said that that in fact the reason that you sold the vessel was not so closely connected to the breach that we have to give credit for it. It's only where the kind of mitigation steps that are taken, or the steps that are taken that provide you some kind of benefit against your claim, are causally connected to the breach in a very strong way, that we can then use that to chip away at the claim. And there they said, effectively, you've got the vessel early, but you've still made a commercial decision to sell the vessel rather than putting it into the available market. And the breach hasn't compelled you in any way to sell the vessel. You've chosen to, take the risk. And Where I think the Supreme Court got that right is that if the vessel had have actually gained money across that time, it wouldn't be open to the disponent owners to say, actually, our claim is greater because we sold the vessel 2 years early, and had you completed the charter party, we would have sold at a higher amount, because the court would then have said, well, no, your measure of loss is still based on the available market rate. So here they're saying, well, there's a difference between something you commercially choose to do and something that you're almost kind of compelled to do by the breach. So that then, and I think that decision then is interesting in the context of this claim, as you mentioned.
Yeah, because when you look at it in the context of this claim, you've got a vessel under detention in Venezuela. It was evidence led by owners that had the vessel not been detained, it would have dry docked, I think in June 2015. And because of the detention, there was a physical impossibility of the dry docking happening. And that there does seem to be, you talk about a strong connection, there does seem to be a kind of strong connection there between the detention and the avoidance of that cost. Now, yes, it may well be that the vessel was then declared a CTL and there was some independent decisions made as to what's going to happen with the vessel. But if you just look at it from in the absence of that other potential cause or independent decision, there does seem to be quite a strong connection between the detention and then the physical impossibility of this dry docking taking place.
Yeah, it seems to me, reading the facts as they're presented in the judgment, that's entirely right. The fact of the detention prevented the dry docking from happening. That seems clear. The dry docking then never happened at the end of the, following the detention, between the detention ending and redelivery. Essentially, all that happened between those 2 points was the vessel was towed to Trinidad from Venezuela and then redelivered without dry docking. It didn't seem to me that there was ever any additional losses suffered as a result of not dry docking the vessel from the disponent owners. That's something that goes to the point you made earlier about the fact that the disponent owners here kept bringing this claim. They kept, bringing this claim. Same thing happened in the arbitration a number of times, and then they appeal it, and then they hear at the very end of it, after a final award, they're appealing on this point again, and it made me think, surely there's a liability there that they're trying to avoid for this 1.4 million. They're somehow facing this claim from the head owners, but no, it doesn't seem like they were ever kind of charged by head owners for that.
Yeah, it just struck me reading this judgment that I would be very hesitant to talk about as a kitchen sink type approach, but almost any conceivable argument was thrown into the mix here. And at times there was kind of criticisms made of the arbitrator, which I don't think the court took too favorably upon, to be honest. And there was this mixture of, well, are you criticizing a question of fact, or are you criticizing a question of law? They went on to criticize this, whether the arbitrator understood a notice of abandonment, and the court found that no, the arbitrator dealt with it and formed a clear view that dry docking would be pointless, and that this was a finding of fact, which does not give rise to any point of law. But then kind of the argument developed into, the arbitrator misunderstanding the legal effect of an unaccepted notice of abandonment. And the court kind of shot that down, I think, quite firmly in saying, well, no, this arbitrator with her experience would not have misunderstood what a notice of abandonment was, and that this was a finding of fact and there was no error of law. But it just seemed to me that some of the points that kind of strayed into this and the way that they were handled was, I couldn't help but read that the owners felt compelled to make all of these arguments so that in another setting, probably an arbitration up the chain, they can say, we made this point, we made that point, we took it all the way to the court on each occasion, we got knocked down, so our claim should stand in its entirety as against the hull underwriters, or against head owners to begin with, and then through to hull underwriters. And this is another example of that.
I think there's every chance that that's correct. The other example that jumps to my mind is the fact that the arbitrator was criticised for not deducting the full amount. In effect, the arbitrator was criticised for giving credit to the dry docking amount in his partial awards, and the court said quite sensibly that in fact the arbitrator was obliged to do that because an arbitrator, in giving a partial award, an interim partial award for a monetary amount, can only give the minimum that the breaching party is certainly obliged to pay. It wouldn't be open to the arbitrator to say, we're going to give you the full amount, including this dry docking expense, and then we'll flip it the other way if the dry docking expense turns out to be something which can't be claimed.
Yeah, exactly. And look, another example, and I must admit I didn't spend too much time on this section of the decision, but it was on the res judicata type argument. And when I read that as a point that was being taken, and that was whether charterers were stopped by res judicata from alleging such a saving. And this kind of went to this point about that owners, having participated in the arbitration, which was on an ongoing basis with a series of awards, were then trying to turn around to say, well, some points can't be taken now, but yet they wanted to have two bites of the cherry themselves. And I just didn't see that at all. And I thought those types of arguments detracted from what I agree with you was really the key type argument here on the new Flamenco.
Yeah, I agree. I saw this res judicata argument, and it honestly didn't strike me as one to spend much time talking about on this podcast, because it just didn't feel like a res judicata situation. It felt like a situation where there are a number of partial final awards or partial interim awards.
Yeah, what did you make of the last point? That, and I must admit, I did find this interesting. Unlike the res judicata point, perhaps, I did at least conceptually think, well, it gave me pause for thought. Well, if this is claimed as an indemnity rather than as a damages claim, can you still bring the saving into the calculations? And I thought that was quite an interesting point. Owners suffered on that argument here because of the way that the claim was framed. And I don't think it was actually clearly framed as a claim for indemnity for what they owe to head owners. It was framed as a damages claim as against charterers. Now, there may be some kind of argument around that, but that was one of the problems, I think, facing the owners. But even hypothetically, if it was framed as an indemnity claim, how does the kind of scope of the indemnity work with a damages claim, which is very clear that you would bring in credits into the calculations in a damages context?
Yeah, and the way the judge answered this was actually on the specific facts of the chart, on the specific terms of the charge party and the specific facts of the case. And he said, what you're indemnified, what the disponent owner has been indemnified against from charterers is the consequences of some irregularities. The clause read that charterers were to indemnify the owners against all consequences or liabilities that may arise from any irregularities in papers supplied by charterers or their agents. And the judge really picked up on that word consequences and said, well, what's the consequence? The consequence has to be equal to the loss actually suffered, which in this instance is the same as the damages regime. And therefore, the indemnity is given effect to, even if we offset the dry docking costs from the total amount which is owed to the disponent owner. And I think that's right. I think that's the correct way to look at what's meant by the word consequence. But I kind of agree with you. I quite wanted to see what the judge would have said if maybe the indemnity wording was broader, about whether you do get to run the anti-new Flamenco argument in a situation where there's an indemnity rather than it being a damages claim.
Yeah, I'm not so sure it would have ended in the same result. As you say, this really turned on the wording of the indemnity, and when you're dealing with indemnities, particularly express indemnities, you're always looking at the starting off by looking at the actual clause and what is the indemnity being provided for. But putting that to one side, if it was a broader indemnity, then the question would be different. You'd be approaching this from the perspective of, well, what was the liability suffered up the chain? What's the claim that head owners are bringing against owners? Has liability been properly defended? Has the owners defended it in a full way, and have they acted reasonably? Once that's crystallised, then if the indemnity clause covers that liability, then it's a straight pass-through. I'm not sure that the credit type argument would come into the analysis as much in that indemnity claim against the charterers. It would be, well, was that a point to be taken in the arbitration up the chain? I would have thought.
I think that's got to be right. If let's just say they were indemnified against any loss of hire, then presumably it's just the loss of hire. The indemnity bites on the loss of hire. There's no requirement to give credit for something else that happened because they lost that hire. Whereas here, when the indemnity was talking about consequences, then the judge could quite easily say, well, the consequence of the detention was that there was no dry docking, and therefore the consequence is the two positions are balanced. I think it is a very interesting question whether the same position would hold true if the indemnity was worded differently.
Yeah, exactly. It's just another example where these cases can throw up questions that sometimes are not even answered in the case, but they get you thinking. And I think it's such a healthy, interesting process. I know I use that word all the time, but I think reading these cases and thinking, well, what if the facts were a little different, or what if it was argued this way, or I've got this case where this might be interesting. Like it's part of this process that I'm really enjoying, Callum, I've got to say. Should we just maybe wrap this up and give some final comments on the decision?
Yeah, I think I'd agree with you. I think this process really does make you think in an interesting way, and keeps you engaged with the law. And just maybe as a final comment, it's interesting this decision alone. You get to look into some recent damages Supreme Court law, see how that's applied in a slightly different context. That helps to expand the body of law that we have on these kind of causative credits, if you like. We've got these interesting procedural points around appeals, around drafting appeals. We've got what I thought was an interesting procedural point around the quantum that you can claim in a partial final award, which is only being the minimum that you could, when interim partial awards, only being the minimum amount which is actually due to you. And then we've got these points just on the difference between an indemnity and a damages claim, and that's even setting to one side the interesting in isolation but not ultimately hugely determinative in this case points on res judicata. So a fulsome award and an interesting one to talk through.
Yeah, I couldn't agree more. And you're right to bring up the nature of this arbitration as being a rolling arbitration, because in my experience, they are not too common where you have an ongoing loss, particularly over years and years, as unfortunately panned out in this case, where you're asking for losses along the way that are crystallising to then be subject to an award. But it's good to see how that works in practice. And I know we do have cases where certain losses are not yet crystallised, but clients want to get on with the arbitration and get them moving. And you can see this is an example of how that can play out, where you might have certain losses that are crystallised, others that are still unknown or are unfolding, and you can get things underway. You get an interim final award and keep the arbitration open pending further losses.
Exactly. And I think that's probably going to be music to some clients' ears, because no one wants to. I mean, look at disponent owners here. They wouldn't have wanted to sit on this claim until they were 24 point something million in the hole before starting the process of recovering it. I think it was the right thing to do what they did and start the process moving and get some money in their bank account for the hire they're missing out on.
Yeah, agreed. All right, Callum. Well, it's a pleasure. Always is. Thank you for listening in to all our listeners. We really appreciate your patronage and having you with us We hope you enjoyed this episode. Thanks, Callum.
Thank you. And just to add, I think if you've made it this far and you're enjoying the podcast, the best thing you can do to kind of support us and keep these things going is just to hit subscribe and listen to them with regularity. It really does help. So please do, and thank you.
Yeah, and last thought from me is we've been getting some great comments back on certain things. So keep those coming. If you're enjoying it, let us know. If you like, certain things addressed, or you think we could do things differently, we are open to suggestions. So yeah, keep the conversation going. Good stuff. All right, Callum. Until next week. Take care, everyone.
Bye.
Bye.